As you know, in recent years, many entrepreneurs have sought to combine their passion for instilling, sustaining positive social impact with their for-profit goals. And hopefully this presentation will help you understand that and do things along that line. As Ann said, questions will be taken at after the presentation is done. And we have two speakers for today. I'm very thankful that they agreed to do this. One speaker is Lindsay Magnano. Did I get that right, Lindsay? I hope. Who represents venture-funded Series C and Series A technology startups and adjuvant small businesses. She advises on business formation and expansion into U.S. markets, contract drafting and negotiation, financing and fundraising from investors, and M&A as her clients are usually sell-side in acquisitions. And also a little plug here, since I guess Lindsay's looking for some extra help here. Her firm is looking for a junior corporate associate and corporate paralegal to assist the three partners and their senior associates. Our other speaker is Siegmar Pohl. He's a corporate partner with Kilpatrick, Townsend, a full-service firm with 20 offices in the U.S. and abroad, including San Francisco, Menlo Park, and Walnut Creek. Siegmar focuses on corporate and IP transactions for technology corporations. He specializes on cross-border strategic investments, alliances, and venture capital. So without further ado, I think Lindsay's going to start us, so give it to Lindsay.
Absolutely, and thank you so much, Jeff, for hosting us. Guys, nice to meet you. We're going to be going over a number of items today, particularly three types of things we're going to be talking about. First, we're going to be talking about benefit corps, then B Corp or B Lab certification, then social purpose corporations and the role of impact investing by social investors. I'm really happy to be here with Siegmar today. I'll go first to avoid too many screen share flops. So here's mine. And oh, whoops, wrong button. Just when you think you know your technology, present. Great. So again, my name is Lindsay Magnano. We're a women and minority owned corporate law firm here in San Francisco. We have a lot of early stage seed through Series B technology companies on our belt. My particular practice, I do have an international edge, so helping with formation or flipping companies. We do a lot of financing here, commercial contracts and sales-side and acquisitions, as Jeff mentioned. I'm going to be talking specifically today about benefit corporations. And my slides are pretty sparse, but you will receive a copy of them, and they actually are contain hyperlinks to the materials that I quoted. So keep a lookout for that coming from Anne later on. But a little bit of a brief background. Benefit corporations exist in 35 states and DC as of today. They're different from nonprofit corporations. So nonprofit, that's, not for profit. This is for profit, and also includes a positive impact on like society, community, environment, number of different kinds of issues. But that's a goal in addition to profit. So just to be distinguished from the two. I've had a couple of clients who had set up parallel entities, nonprofit, to access grant funding, for profit, B Corp, to access VC financing. And that's a possible structure of two different, with licensing agreements in between, arm's length, of course. But we just want to make sure we're differentiating from nonprofit corporations at this time in the presentation. So components are relatively the same as a lot of other, just general corporations, but for the most part, in some jurisdictions such as Delaware, if you're forming a public benefit corporation, in your certificate of incorporation, you're going to identify that specific public benefit. You're going to have PBC at the end of the name. That's not necessarily a thing in California. You don't have to do it that way. You can just have a general benefit stated. In bylaws, again, generally the same for Delaware as a regular Delaware C Corp, but you can amend them to specify the benefit as specifically as you'd like, as well as choose a subsection of the board to operate the public benefit purpose. Finally, stock certificates. If it's a Delaware PBC, it needs to actually specifically be conspicuous and obvious that it's a PBC. And then, of course, there's all the rest of the usual incorporation formation documents, board consents, stock agreements, et cetera. So I'm just briefly bringing up the items that might be slightly different at formation. Caveat on institutional financing, and Siegmar and I are going to talk a little bit more about this towards the end of the presentation. For the most part, Delaware Public Benefit Corp is an option for social investors. However, most of the VCs that we work with, even if they are running social impact funds, still prefer Delaware C Corps. That is something that we've noticed. So while we'll be talking a lot about the Delaware PBC today, I will just caveat that with, it could also be something like a Delaware C Corp with a B Lab certification that might do the trick for social investing. Going forward, we're going to be talking about, or I'm going to be talking about a few different things today. I'm going to be talking about the history of and the differences between the Model Act and the Delaware PBC, and a few very distinct benefits with regard to this type of entity. So first, but not last, and definitely very important, the Model Act came from B Labs. Delaware PBC is Delaware's statute. The differences are about 4 or 5, I think, that come up pretty regularly. Delaware does require a specific benefit to be put forth in a certificate of incorporation. California and the Model Act don't necessarily require that you can just have a general public benefit. Second, there's a third-party standard imposed in the Model Act. In other words, there has to be some sort of independent organization saying that, yes, we certify you herein to be socially and environmentally purpose-oriented. Delaware does not require this sort of requirement of a third-party standard, so that's another difference. The Model Act third will require publicly traded benefit corporations to appoint a benefit director. So a benefit director is usually someone in the board of directors who's required to, state his or her opinion in writing as to whether the corporation's meeting these beneficial goals or purposes. And a benefit officer could also be appointed under the Model Act, and he or she would prepare the annual report. But Delaware's law does not require either of those positions to be put into place. As far as decision-making goes for directors, Delaware, so if you have a PBC and you're a director of a PBC, you are supposed to balance 3 factors, which are, and I'll read them for you: the pecuniary interests of shareholders, the best interests of those materially affected by the corporation's conduct, and the specific public interest as defined in the certificate of incorporation. So there's a balancing act that you have to do to try to accomplish the goals of all 3. The Model Act requires directors, conversely, to consider the effects of any action or inaction upon 7 different groups or interests: shareholders, employees, customers, the community, short-term interests, the ability of the corporation to accomplish beneficial purposes. California also has a very, very robust list as well, and that is listed here under Section B. So if you click on this link when you get these materials, you can see the very, very robust list, but it has a similar smell as the Model Act. Enforcement actions. The Model Act does create a new right of action called a benefit enforcement proceeding. That's very similar to California. California also has a public benefit enforcement proceeding, which can be brought by the corp directly or derivatively by people who own 5% or more. Delaware does not create a special enforcement proceeding for PBCs particularly. A shareholder can just bring a derivative suit like any other, against the company like any other corporation. So those are the main differences that you'll see between Model Act and Delaware. The codes are there. I've listed the codes for Delaware and also the codes for California in case you were forming in California. One of the benefits that I think they've already touched upon, but we'll try to touch upon very briefly here in my allotted 15 minutes, is that these kinds of entities, whether they're in California, Delaware, or pursuant to the Model Act in another state, they do require an annual report of sorts. Model Act, it needs to be an annual benefit report. It needs to be delivered to shareholders, and it must be made available to the public. California, very, very similar, also requires a publicly accessible benefit report. Stating the company's environmental, social performance, whatever the goal is, as measured by, of course, that third-party standard. You have to identify the people who own 5% or more, and imposing, a supermajority voting requirements for certain major corporate actions like mergers or sales of almost all the company's assets. So a little bit different from the Model Act there. PBC, they actually call this a biennial report. There's, again, no third-party standard that needs to be met. It doesn't even need to be made public, although you can allow for that when you're creating the company in your certificate of incorporation. And it also doesn't require, again, this third-party standard unless you allow for that or you specify that in your certificate of incorporation and bylaws at the very formation stage. You must provide goal progress reports or statements to stockholders at least every 2 years. So there is some accountability here. The shareholders and the public in some states get to see what you're doing and how you're doing it and how you're making progress. And that's really, really fantastic, especially for people going to benefit number 2 who really care about that. So benefit number 2, benefit number 3, accountability, and benefit number 2 are going to be quite similar. There might be some overlap here, but director consideration of the beneficial purpose. This entity is fantastic for that because it really kind of gives teeth to exactly what the company is trying to accomplish besides profits. So this makes it kind of like a good marketing play or a good advertising play, and makes you attractive as a company to some investors and to consumers who are socially conscious. So directors are not necessarily subject to a breach of fiduciary duty just for acting in a manner that's unrelated to financial interests. They can also act in a manner related to the benefit goals. Corporate law practitioners are generally familiar with Delaware PBCs, as with all Delaware companies, just because of the convenience factor of filing in Delaware and the fact that it is a gold standard for a lot of national and international companies. But generally speaking, it's also really easy to transition a regular C Corp to a PBC by amending and restating the certificate of incorporation to include that specific purpose. So again, very, very transparent, very attractive. There's definitely some teeth here to directors. One of the things where there's a little bit more responsibility on the director's end that directors in like a PBC would have more responsibility than in a regular Delaware C Corp is this biannual written benefit report to stockholders. There also is kind of an issue in terms of balancing these 3 things. And again, shareholder interest in profits, best interests of those materially affected by the PBC's conduct, and the actual benefit that's we're attempting to try to be conveyed. You can, as a director, be sued for failure to do so, and failure to balance these things properly in a derivative action. Although there's a great article by, and let me get the name of this, it's linked in this PowerPoint as well, called Committing to Do Good and Well, which is by Fordham Law Journal, about how very problematic this balance to strike is. So just very briefly, and I don't want to overrun my time, so if you have any questions, please save it for the end. I'm going to talk a little bit about director liability here. Background, we'll start with ordinary corporations. Let's just think of a Delaware C Corp. You're really finding liabilities on like the waste standard. We're excusing some liability with the Exculpation Clause. And of course, if you have a disinterested director approval, that usually tends to get directors off the hook. So those 3 mechanisms that apply in regular C Corps, I'm just bringing that up to give you a little bit of a background of how directors could get off the hook in a regular corporation context. Waste, of course, means like, this deal was financially detrimental, like not the best deal for the company. Exculpation clause is usually something that says, the company will absolve this liability, and the person who's alleging that the director acted inappropriately has to show non-good faith actions, to get around the clause. This clause is generally adopted in most Delaware company formation documents, so it's not a surprise that it would be in there. And of course, whenever there's a conflict of transaction, a disinterested majority director vote approval with the guy who's interested abstaining from the vote is usually helpful to get around director liability. So in this benefit corp situation, because of the balancing of interests, there's a little bit of ambiguity on how the courts will interpret whether the director's action was appropriate. So there are three main issues that the Fordham Law Journal article talks about that I think are really, really helpful and on point, which is the duty for ordinary operating decisions, what happens in conflicted transactions, and what happens upon sale. And it does a really good job about pointing out the nuances and the ambiguities regarding director accountability. So one of the interesting things that I thought they brought up, and again, this is linked here in the PowerPoint, is this issue of possibly no monetary damages. And this emphasis on injunctive relief by the Model Act, and questioning whether a director can be held liable, for example, for failure to consider. Not pursue or create, but failure to consider some sort of impact that a business decision of a PBC would have on some stakeholder. So, do those same exonerations provisions apply, exculpation provisions apply? It's somewhat vague there. Another thing that comes up that's somewhat tenuous is that this waste standard of balancing financial interests against environmental interests, for example. So, a director would have to be grossly negligent in informing themselves about the impacts of the disputed decision on a variety of different interests at play. And so, how do we balance the goal of, for example, being more environmentally friendly and choosing containers for the product that are a little more expensive than the general containers, against the fact that we don't want to spend over and above what's normally required. So balancing the environmental interest in this example versus the cost interest and the waste analysis interest is something that is a little bit tricky. And also showing damages related to that same example. If you choose the non-environmentally container option and non-environmentally friendly container option, but the company comes out financially better because they're cheaper anyway, how do you show that loss? And so there's some ambiguity about the balancing of those factors. There's also a similar ambiguity because you have all these factors to consider as to conflicted transactions. So usually if, let's say you're a director of a benefit corp, PBC, he's a majority owner, he's on the board, and he enters into a transaction with his other company, Company B, can he get away with doing this kind of a self-interested kind of conflict by saying that, Company B that he also owns provides environmentally friendly containers, whereas the other options on the market are not environmentally friendly, and the company's goal is to promote the environment. There's some interest in that, and the article goes on to say that we're thinking that if the other, as with other corporations, that the other directors who are disinterested vote on that, and absent showing that it's much, much more expensive, he should be able to justify that decision. And then, of course, there's lastly a duty upon a sale of control. There are some issues when, what happens if this PBC is sold to a company or an acquirer who does not share the same beneficial goals or purpose, or who is even anti to that, but yet, the stakeholders make a good profit. There's a lack of damages issue, but there's also an issue with regard to the balancing of those three factors, and how the court would come in and say, you didn't balance this appropriately, especially in California when there's like a list at 14,620 B and C that's really, really long and robust. So as a result, D&O insurance can be a little bit pricier given all these ambiguities for this type of entity and for the directors of this type of entity. Going forward, I'd like to stop sharing my screen so I can turn it over to Siegmar. You want to take over, Siegmar?
Yes, thank you, Lindsay. So I'll try to share my screen now. And start here. Yeah, thank you. Again, my name is Siegmar Pohl, and Lindsay and I, we wanted to give you an overview over the different entities or certifications that are commonly described as B Corps, benefit corporations, or also maybe social purpose corporations. And Lindsay just explained what the entity is that is actually called benefit corporation, or PBC, public benefit corporation. I'm now in the next unit here going to talk about the B Corp certification, and it's important to differentiate because some people refer to the benefit corporation simply as the B Corp because it kind of sounds like C Corp or S Corp, and but the certification is something completely different, even though we'll see there is some overlap. So the B Corp certification is a third-party certification administered by another nonprofit, which is called B Lab or B Labs. And Lindsay already referred to that a few times. You know, what is that certification? So B Labs is an organization that came together a number of years ago, trying to certify all kinds of companies or entities or even sole proprietorships really around the globe. It's not limited to the United States or specific states. And today there are at least 3,500 certified B Corps. Again, that could be all kinds of entities in more than 70 countries. And famous examples or well-known examples of public companies that are actually certified as B Corps is Patagonia, Laureate, Silver Chef, Natura, and there's a long list of public companies that are actually certified today. There are also other B Corps that are subsidiaries of public companies. For example, Ben & Jerry's and the Sundial brands, and New Chapter, which is owned by Procter & Gamble. So the certification is a tool to measure the entire social and environmental performance of a company, not necessarily only, you know, we'll talk more about these specific purposes, and Lindsay already identified the ones that apply in the Delaware or California Benefit Corporation. Those are more limited. Those are the purposes that the founders code into the Articles of Incorporation, but the certification from B Labs is a lot broader, and we'll see on the next slide what that is. And the purpose of getting the certification is really to commit the stakeholders to the impact in the long term, not, you know, specific short-term profits, but make sure the stakeholders are committed in the long term, at least as long as they hold the certification. So how is that being done? How does B Labs come into a company, or how does a company come to B Labs and get certified? So there is a tool called the B Impact Assessment that is basically a long list of criteria that B Labs has come up with, and it evaluates the company's operation and its impact on workers, on the community, the environment, customers, and it's a very broad list, you know, including supply chain, input materials, even charitable giving, and employee benefits. Does the company treat the employees fairly? In order to get certified, there's also certain transparency and accountability required in coming up with these assessments. And the way to do it is it's fairly easy. You know, you can go online to B Labs. It's a free online platform, and you can just get started and use their analytical tools and benchmark your own data. And there are over 300 factors, 300 indicators that you could self-assess and then see if you fulfill the requirements or to which extent. So that's the sort of the assessment. But there's also more, let's say, there are more hard legal requirements to be certified. What do you have to do on the legal side to either get the certification or to maintain it? So the B Corp legal framework is designed to help protect the mission of a company through capital raises or leadership changes, for example. But it also gives the company the flexibility that Lindsay talked about for this other set of companies, basically the actual benefit corporations, that gives the company the flexibility to evaluate a potential sale. Like, you know, who do I sell this company to? Is the new owner going to be as sustainable, for example, as I am, and then also other liquidity options. So the certification, and this again is broad around, basically around the globe, may require reincorporating, and then in the US it could require reincorporating as a formal benefit company or benefit corporation, or for other entities, you'd have to update your articles or make other changes. And here I'll just quickly go through what that could look like for different types of entities. And again, that depends on the country or the state. So there are three ways from the legal side to get certified. First is you have to adopt the benefit corporation structure within 2 years of getting certified. So if you're currently, let's say, a C Corp, then you can get certified if you sort of pass the test, so to speak, of the assessment. But then you also have to commit to becoming a formal public benefit corporation within 2 years of time. For example, in Delaware or California, like Lindsay just described, there are these corporate forms of the actual benefit corporations. There's also, and I'll touch upon that later on, there's also a different type of legal entity in California only and a few other states, and that's called the California Social Purpose Corporation. Again, another bucket, and that's why this is kind of confusing, and hopefully our talk today helps to differentiate a little bit. So the first, if you're a corporation, you're supposed to reincorporate or amend your articles and become an actual benefit corporation, or in California, you could also become a social purpose corporation. So if you're not a corporation, but if you're an LLC or something similar in other countries, or an LLP, you're supposed to add specific mission language in your operating agreement. And we don't have to go through this, but just as an example, the language that's required is actually by B Labs, the third-party certification entity, is actually very specific. So you have to have two clauses. One is a purpose clause, where you're actually stating what the purpose of your LLC or your partnership might be, and then a director's clause that deals on the certification side with some of the issues that Lindsay just described, how to balance, how to consider. So for the certification, the management, if it's an LLC, the managing member or the manager needs to consider at least some of these effects on the members, on the workforce, on suppliers, and so forth, the entire list. That's what I find the most interesting part about this here on this slide at the bottom, number B. The manager shall not be required to regard any interest as a dominant or controlling interest or factor, which oftentimes, you think price and money and shareholder profit might be the controlling factor, but now you're coding into your agreements that is not the case, and thereby giving the managers more flexibility. All right, still talking about the certification. What can you also be a C Corp if you have a sole proprietorship? And yes, you can. If that's the case in the US, sole proprietorship, you would have to sign an agreement with B Labs that you will adhere to certain standards. And here's some of the key terms, that you'd have to write into this contract. First of all, that you're agreeing that your submissions will be certified and reviewed by B Labs, that you're agreeing for 3 years, that you're adhere to these standards for at least 3 years. And now we're back to the impact assessment, that you earn at least 80 out of these, out of 200 points that are stipulated for sole proprietorships. And then you can, then you're entitled to kind of bear that seal, get that certification as a certified B corporation, even as a sole proprietorship. But interestingly, of course, there's a fee. You can only kind of keep and maintain the certification if you pay a certain amount per year. and that's dependent on your sales. If you make less than 150,000, the annual license fee is $1,000. And then as you can see here, it goes up to, for larger revenue tiers, it goes up to 50,000 a year, or if you make more than 1 billion in sales, then it depends. It's basically negotiable. So that's the certification, but even B Labs, who came up with the certification years ago, that was before the actual benefit corporation structure even existed, said, well, that's not enough because we're constrained by traditional corporate statutes that mandate maximizing shareholder profit. And then even the B Lab founders had lobbied initially to actually pass the benefit corporation statutes and pass the legislation that Lindsay described. So that's all we're going to talk about today about the actual certification, really to contrast it from the actual benefit corporations, but also kind of show it's broader. It's a certification, but it may require that your entity actually becomes a formal public benefit corporation. And then in California, like I said, you could also become a social purpose corporation. And I just want to briefly, more as a contrast, that's another option, describe what that is. Again, it doesn't exist in many states, only in California, Washington, Florida, and to some extent in Texas. Here's some of the code sections in California that regulate social purpose corporations. They used to be called flexible purpose corporations. And these types of entities also promote the positive impact of the company's operations on employees, community, and or the environment. And a good way to remember what this is actually doing is that writing this into the corporate formation documents, you're providing an additional safe harbor protection for the management that had already been protected by the business judgment rule. The management has some leeway, has some flexibility in at least reasonably decide what's the best for the shareholder profit, and in laying this out, that the management is entitled to promote the positive impact on employees or on the environment. The safe harbor just got a little bigger, and there's a little more flexibility for the management before it has to be conscious of potential shareholder lawsuits. And your last point on this slide, it's interesting. All an SPC, a social purpose corporation in California, needs to do is at the end of the year, it needs to include a management discussion and analysis addressing the purpose. It doesn't have to specifically say what was done, how much was done, and use a certain standard to do this, but at least it has the management of the SPC has to address and discuss what was done or had been tried to be done. Just very briefly, to form an SPC, it's a for-profit entity, can be formed just like a normal stock corporation, but you have to include a general purpose. It's really any lawful purpose. It can be a bank, and there are certain other exclusions, of purposes that you can't pursue as a social purpose corporation. But then you also have to include at least one of multiple specific purposes, and those are often along the lines of the purposes that a nonprofit could pursue. Educational. It could be, for other public purposes. Just like any other nonprofit, but you have to specify it and then get set up as an SPC. Again, it's a little easier than in a traditional public benefit corporation. It's the directors just have to consider the impact, not necessarily maximize one factor or another. Just keep it in mind. and then do the annual report and make it available on the website. And that's really all the board or the directors have to do. They're not legally required. They only have to consider it. They don't need to use an independent third-party standard to assess or analyze the social impact. And these lower standards sometimes are appealing to companies like startups, for example, that don't want too much red tape or spend money on preparing these annual reports and analysis. But since it's a lower standard, some people say, well, social purpose corporations is just, it's just a label and it's just greenwashing, and these entities are running their business just like any other entity also. And with that, Lindsay and I were gonna maybe just, or Lindsay, did you want to do a quick comparison, just
Sure.
briefly summarizing what the differences are, just in a nutshell?
Absolutely. And I have no slide for this, so you're just going to have to look at my face on this one. But we talked about three different things. We talked about benefit corporations, which can be an actual entity in many different states. They're called benefit corporations. In Delaware, they're called public benefit corporations. They're in about 35 states. You file an articles or certificate of incorporation that states a general and or specific purpose. We've then talked about B Corp certification, which by B Labs, which is that independent third party that I mentioned. Then it can be generally any entity type. We have a law firm colleague, also solo small firm, that is an LLP, but got their B Lab certification. Although, like Siegmar said, a lot of the people who actually get the B Lab certification are already benefit corps or public benefit corps. And sometimes there's conversion issues or conversion necessity in that respect. And then, of course, Siegmar talked about SPCs, which are only in certain states, not as many states as the benefit corporations. So California, Florida, Texas, Washington, you have to have a general purpose, but also a very specific purpose of helping the employees, the community, or the environment, or a combination of those three items. So that's our little three in a nutshell summary, and I'll turn it over to Siegmar about social impact investing trends.
Yeah, thanks, Lindsay, and yeah, please chime in your experience. So we've seen in the last few years more companies, also startups, that are looking for external funding, also venture capital funding, ask about, should we be a benefit corporation? Would that help us or hurt us? And so here are a few trends that we see. So benefit corporations, or really also B Corps or also SPCs, do have additional access to these types of sources. There are philanthropic grants, for example, governments or foundations. They basically offer additional funds and under programs that pursue a certain mission. It's philanthropy, and that will help if you are a benefit corporation, or if you're certified, that you can show you're pursuing this mission. There are also other sources that are available to companies from foundations that are called program-related investments. So some of the foundations have a certain program and say, well, we'll invest. So that's not a grant, but we want repayment at some point, or at least some of the investment is supposed to be repaid, and those are called program-related investments, and it's worthwhile to kind of look, if you're in that space, to kind of look through different foundations and what they fund and what they support. For the foundations, it can also be good because foundations sometimes have to, on an annual basis, to distribute certain money, and then they're like, yeah, so how do we distribute this money? How are we making sure we're still following the foundation's mission? And then benefit corporations can be the answer. Then angel groups, more and more angels like to do good as well as get a return on their investment. So angel groups like to look at B Corps, at benefit corporations and SPCs. There's also impact venture capital. Almost all the VC funds explicitly now invest in social ventures. So it's a little bit undefined for many of them. You know, are you required to be a benefit? You know, which one is it? But as long as there's social ventures, they might look at you because they have impact funds. Same for corporate sponsorships, really. Sometimes big corporations have a foundation on the side that will invest in something that does good. And then also, if it's not direct investment, there could be strategic partnerships. And as some of you might know, there are even specific accelerators out there now that that invest or focus on public benefit corporations. Here's a link to a website that has a list of good sources of funding and might be of additional help. We can circulate that link after the presentation. So here's a little bit of a trend. You know, what have we seen? And it basically, as you can see, increase in on all levels. Meaning there are more venture-backed benefit corporations now than there were a few years ago. There's also an increased deal flow, meaning more money is actually being poured into these either certified B Corps or actual benefit corporations. And here's some trends according to studies. You know, the investment has gone up 33% in the last 2 years, or multiplied 14-fold since 1995, and some reports even say $1 in $5 under professional management in 2016 already was in benefit corporations. And by now, even the mainstream investors like Anderson, Horowitz, Benchmark, Union Square Ventures, they even and all major Silicon Valley VC firms invest, I mean, not exclusively, but they will invest in benefit corporations. And then, interestingly enough, even some VC firms have become certified as B Corps themselves. There's one example is Foundry Group. So they thought it might help them, or they wanted to be B Corps, and so they got certified. Yeah, why do people do that? Lindsay already mentioned some of it in the talk about the benefit corporations. So you do want to do good and have a social impact alongside a financial return, and sometimes you can do both. There's the Nielsen survey that says nowadays a global majority of people around, meaning global all around the world, is willing to pay more for products and services from companies that are committed to social and environmental impact. It's just a trend, especially the younger generation, the new consumers. For example, here 2/3 of the 22 to 34-year-olds are likely to invest in a socially responsible company. That's what people want to do. And then if you're on the investor side, it gives you an assurance that you eventually can also hold a company. You've invested into a company, you've told your own investors that you're following a mission, and then with the certification or the legal form, you actually have a tool to hold your portfolio companies accountable. And last but not least, so sometimes we get the question, should we just become a benefit corporation and then we'll basically open up new funding sources? And the answer is yes and no. And it can be beneficial, but what types of companies are actually the ones that are being chosen? So investors see that if you are dedicated to perform under your mission and make sure your company is, for example, sustainable, that means you're also have a better operational performance. You're organized better, so to speak, in your day-to-day dealings. And that will eventually, in most cases, translate into cash flow. Also, and that might kind of come together with Lindsay's issue, like where she described the issues about balancing how do you balance this? So one way to what people have seen is you may not be able, with the sustainability and social impact goals, you may not be able to make a short-term profit as well as other companies, but empirically, a lot of these companies have more long-term success. And under the business judgment rule, you could already say something like that. If the board says, well, in the long, to use Lindsay's example, if we buy the more expensive container, this year we might be less profitable, but in the long run, maybe we have more consumers that will buy our products, and that will help us in the long run. And also your employees might like it. The term here is, it might supercharge your talent, which it often does, especially for Generation Z. And with that, Lindsay already talked about, Delaware C Corps are still preferred for investors, but if you have a benefit corporation that's more or less, in everything else, it's almost identical to a Delaware C Corp, except with regard to the mission and the purpose. That makes venture capitalists comfortable because they know their shareholder rights, their information rights, their preferential rights are always are going to be the same, but at the same time, we know the company's going to perform and pursue its mission. And so the best way to kind of sum it up is to say, it's not, of course, it's not good, or it's not going to help each and every company to just become a benefit corporation. But if the benefit that you're codifying and pursuing is also your competitive advantage as a company, if pursuing this social purpose or the environmental purpose or doing good for your employees gives you the competitive advantage in whichever way, is it consumer perception or other ways, then the benefit corporation will codify this, make it transparent, and give and make investors comfortable. And if that's all coming together, then converting to a benefit corporation might make sense. And some of the venture capitalists even use, if you're talking about the certification only, the B Labs certification, some investors even look at your impact assessment that you're preparing for the certification to understand your business better and see what your strengths are. And so for all of these things, these three elements these three animals, so to speak, certification, B corporation, or social purpose corporation can be useful, and investors are appreciating that. Yeah, Lindsay, did you want to add anything to the trends, or are we ready to open it up for questions?
Sure, I'll just add a few things. Generally our practice area is limited to really early stage startups. So I don't have as broad of a portfolio as Siegmar does. But I will say some of the social impact venture funds that we have sent our clients pitch decks and executive summaries to are still, very brainwashed to ask for Delaware C Corp, Delaware C Corp, Delaware C Corp. And for those people who are not familiar as to why that even is, it's because of the fact that, Delaware has great precedent. It's so easy and quick to file things in Delaware. Investors are very familiar with Delaware. So in that sense, most of our clients are Delaware C Corps. For those of them who do have the social edge, they do get the B Lab certification. And going to one of your questions on the chat, I'm actually not, I've only had my clients go to B Labs for that third-party certification. So Siegmar, if you know any other ones, now would be a good time to chime in on that. But for the most part, we're still in the early stage forming a lot of Delaware C Corps for venture investment. We have not converted anyone yet from a Delaware C Corp to a Delaware Public Benefit Corp for venture purposes. They've usually just been financed anyway with their Delaware C Corp with their B Lab certification. I would say, there's like a handful or two of investors that are firms that are out there really doing social impact investing. But I do think some of even the larger firms that are out there who are not focusing on social impact investing are certainly doing that in 2020 and 2021, given the momentum that we've seen in this past couple of years towards really being more cognizant on things like the environment and social justice and our fellow neighbor. So they're at least paying more attention to those issues, which I think is really, really great for social impact entrepreneurs.
Thank you. Yeah, I don't know any other certification entity either. B Labs has actually trademarked these certifications. So anything that would sound similar would, would be competitive. So it's really B Labs has created this, and it's their certification. If there were other entities out there, they would have to call it something else. But I'm also not aware of any.
Awesome. So I think we've got 2 minutes left. If anyone in the audience has any, questions that you'd like us to answer, I think we answered the one that was, oh, wait, maybe there's more. What does B Labs charge? Siegmar, do you want to explain the fee for the application?
Yeah, so the application itself is free, but the certification comes with an annual a royalty that could go back to the list. It starts for small businesses. It begins at 1,000. So if you have annual sales of under 150,000 a year, then the fee is $1,000. And then, as you can see here, I haven't put all the tiers on the screen because there are many. It goes in small increments, but it goes up to 50,000, and then it's more case by case if you have sales of over $1 billion.
Awesome. So those are the last 2 questions we have. Let me just double check the chat to see if there's anything else that we might have missed. The certificates of materials Anne says will be coming out on Monday. My slides will also be in those materials, I believe, Anne, and it has the links to the materials that I use, especially this Fordham Law article, which discusses kind of the ambiguity and the director issues. Again, my name is Lindsay Magnano. I'm from Smith, Shapourian, Mignano, which is a women-owned corporate law firm here in the city. And I'll let Siegmar close and introduce himself as well, reintroduce himself.
Yeah, thank you, Lindsay. Yeah, again, my name is Siegmar Pohl, corporate partner at Kilpatrick, Townsend, and it's been a pleasure being with you today. I hope the presentation brought some additional clarity to what I would call jungle of terminology in the B Corp, benefit corp, and special purpose jungle. And it's been a pleasure being with you today, and hope we'll be in touch and see each other in person, hopefully at any of the CCCBA events soon.
All right. Well, nice to meet you formally, or I guess virtually, Siegmar and Jeff. And thanks, Jeff, for planning this. It was great. Anne, do you want to close?
Yes, I was just thank you, everyone. Materials and evaluation form should be sent to you Friday, no later than Monday, and certificates as well. Thank you all very much for coming. Siegmar and Lindsay, awesome presentation, and we will see you all soon again in person sometime, I hope. Thanks, everyone.
Thanks,
Bye-bye.
everybody.